important benefit programs. It can really be a detriment on the person being able to afford their care and getting bad results for the family. So in setting the stage for this, I'd like you to just understand what the average costs of care are in our area. In Appleton, for instance, you'd be looking at just under $10,000 a month for a skilled nursing facility. And assisted living facilities have a pretty wide range of costs. But on average, I'd say most of my clients range pretty close to about $5,000 a month. A lot of factors go into that. That's not all cases. The level of care that somebody needs in an assisted living facility is going to be a very big factor in the cost of that care. And then also, of course, where they choose to go. And different places have different pricing for those types of things. I've had people who need a very modest level of care be under $4,000 a month. I've had people who need pretty significant care be over $7,000 a month in these assisted living facilities. So, take cost with a bit of a grain of salt there. But the point is that most people in retirement would say, boy, I don't have that kind of income on a monthly basis where I can just readily afford a $5,000 or $10,000 a month bill, which means we'd be tapping into assets pretty significantly in order to make up the difference between the income and the cost of care. And so are there things that can be done to make sure that I can afford care without exhausting all the assets? Well, the context that comes up when it comes to gifting is so commonly people misinterpret the rules about gifting funds. And a lot of times it's a well-intentioned son or daughter who looks into things and then convinces mom or dad that, maybe you should do some gifting to preserve some of the assets, without knowing what the repercussions of those gifts might be. So here's the kind of the nitty-gritty on this. There is not an ability to give gifts of the annual exclusion amount and maintain possible eligibility in the future for long-term care programs like Medicaid. What I mean by that is so many people know about this $10,000, $12,000, $15,000. Oh, what's that amount you can give people every year without any taxes? The actual answer for that is an annual exclusion for gift tax purposes and reporting to the IRS. The number is $15,000. However, that is totally irrelevant for long-term care. It has nothing to do with long-term care laws. The $15,000 you can give to each individual each year, and married couples can give twice that amount. They can give $30,000 because it can be considered from both of them to every individual they've ever met every single year. And that law has to do with, do you have to report this on a 709, which is an IRS form, to tell the IRS about taking funds off of your lifetime exemption amount, the amount you can pass of wealth without incurring a gift or estate tax. Well, your exemption amount is $11.7 million. You can give, for most people, their entire estate away, and you don't have to worry about estate or gift taxes. There could be some income tax implications to transferring things depending on the type of asset that it might be, but you don't care if you're concerned about the cost of long-term care. You don't care about estate taxes in most instances, because my clients who have $10 million, they're not particularly worried about being able to afford a $10,000 a month bill. So if you're concerned about long-term care expenses, that probably tells me you don't care anything about estate taxes. Well, that $15,000 per year you can give away to each individual, that is solely, hey, I don't have to report this to the IRS. That is not a safe haven for if I go into the nursing home, is this money safe from long-term care expenses, or there's no effect or anything? There is a huge effect. So those sets of laws have nothing to do with one another. One of them is the IRS regulations. One of them is the Medicaid laws. They don't coincide or play nice with one another. So I've had so many people come in and we talk about, okay, mom or dad they've had a health event or a decline in their health, and they're now transitioning into a care facility. And one of the questions I'll inevitably ask is, have they transferred anything for less than fair market value over the last 5 years? And we would need to know about any amounts that got transferred. And transfers for less than fair market value would be gifting money away, of course, because you're not getting fair market value back. Selling for less than fair market value. You can't sell the kids your cottage for $2 and say, oh yeah, they bought it, because it's still a gift of everything but the $2 you got back. Because any of those types of things where you're not getting fair market value back are considered gifts, which is a divestment of that money. And divestments that happen within 5 years of an application for assistance in paying for care are going to have an effect on your eligibility to get that assistance. And the way they're going to calculate that is look at how much money got divested, given away for less than fair market value, and calculate based on a divisor that changes annually, how long could this person have potentially paid for the care with the money that they gave away? And that's the length of time that they're going to say, okay, once you're eligible for our program financially, we're not going to give you any assistance for that period of time based on our calculation. So for an example, if you give away like $92,000, that's going to be about 10 months of, okay, we're not going to help you once you're out of money and financially eligible for our program. We're not going to help you for 10 months. Come back in month 11 and we'll start paying for care. So I've had many instances where there's been this decline of somebody. We ask about, have there been divestments? And I hear from a child or somebody involved, well, yeah, we had mom do some gifting over the last couple of years because we knew she was going to go into a nursing home soon because her health was declining. So, but she only gave away the, $15,000 that you can give to everybody. So we're fine, right? And the answer, of course, is no, you're not fine at all. You're in huge trouble and we have a problem that we're going to need to try and correct. So just be very careful that if you're making any kind of gifts, that if care could be coming within the next 5 years, that you're incorporating the advice of an elder law attorney into, okay, what is the effect of this? And what's our backup plan if we maybe don't make it out 5 years? Because there's ways to get some of that toothpaste back in a tube and get good results. But I can't help on situations I don't know anything about. Or any attorney. I mean, we need to be involved in order to give guidance. There's a couple of exceptions to the rules around these divestments. One of which is if somebody has a long established pattern of giving, like, oh, for my kids, I always give them $100 on their birthday, and my grandkids, or I've always given to my church every month. If it's long established, meaning if it happened even before the 5-year look back period, and it continues, there's no gaps in years or anything, and it doesn't exceed 15% of the person's gross income, then the state can assume, okay, they didn't do this for trying to get qualified for our program. We're not going to assess a penalty on this. It still is a little hit or miss. You can end up having some arguments with the caseworker who's processing the application on, was there an unbroken pattern, and do they qualify for this exemption yet? It's not perfect, but certainly if somebody's continuing to gift, It's a priority to not exceed the 15% of the adjusted gross income and never have a broken pattern of it. Just very critical that everybody understands that there is not a safe haven of $15,000 that you can give to anybody. Those gift tax rules have nothing to do with long-term care. And if that's the only takeaway that you guys have from this kind of program, that would be an important one. In addition, there are a lot of instances where a family member has maybe retired early or is allocating time to help a loved one, be able to stay in their home, and they're providing care, and that's helping keep the person maybe at home as opposed to transitioning into a facility. Well, in a lot of instances, it's a priority for, the parent or whoever it is that's receiving the care to be able to pay the person for their time, because they're providing a lot of, valuable services that otherwise would probably be, $25 an hour or more potentially to a licensed caretaker, an at-home care facility. And so they're choosing, okay, my daughter's allocating a lot of time to this. I want to make sure I can compensate her. Well, one of the rules is that if you're ever going to try and apply for assistance in paying for care, you need to, before you start paying your daughter, to actually have a caregiver agreement in place before any money changes hands, because you have to have a notarized caregiver agreement in place prior to the care, or else the state is going to say, when you apply for care, okay, all of that money that you were paying your daughter over the however many years or months it might be that you were providing payment to her, those are considered divestments because you didn't have a caregiver agreement in place. And so a lot of times we want to catch that with our clients and draft a caregiver agreement so that they have that in place, so those payments don't, after the fact, once the care becomes too much maybe for the child, or they need a more protective environment where they transition into long-term care, that they don't have a problem being able to qualify to pay for it with an assistance program, just because they didn't know that they needed to have this contract in place ahead of time. So critical that you don't end up having those caregiver payments be considered gifts. Got to have that contract in place. Just absolutely need one there. When it comes to gifting also, even gifts prior to our look back period might not always be an ideal way to plan for care. People should know that gifts come with what's referred to as a transferred cost basis. And what I mean by that is, if it were, say, a gift of the family property, the family cabin, for instance, that has, been in the family for a couple of generations, and it's a priority to make sure that that resource stays in the family and the family's able to continue to use it and is not needing to be liquidated to, pay for the care of a parent, for instance. That one comes up a lot. And so one of the questions we get on it is, okay, what if we sign it over to the kids? That's a gift. And a transferred cost basis would mean that the IRS pretends that your kid paid for it, whatever you might have paid for it many, many years ago. And so that means it comes packaged with all the capital gains tax, so that if those kids ever had to sell that property, they're going to be hit with a significant amount of capital gains on the difference between the original, purchase price and the ultimate sale price. And since it's not in that person's estate anymore, they would not be able to get a basis adjustment to fair market value at the time that they die, which means if the parent owned it or was considered the tax owner of that property when they died, the kids would receive a basis of the fair market value on that day, which is probably significantly higher than the original purchase price 40 years ago. So signing it over to the kids is usually not the best tax planning tool, because the cost of the capital gains probably exceeds the cost of doing planning that would get rid of the capital gains and preserve the property simultaneously. So not very good planning to do those types of gifts. That's another thing that I'd greatly encourage people to reach out to an elder law attorney, such as our office, to talk about strategies and implement something that is going to take into account not just the potential for care coming up, but also minimizing taxes and having a backup plan if the timetable changes for care. Because a lot of people kind of shoot themselves in the foot where they implement a plan, person's care timeline ends up being not what they expect, and then they don't have a backup plan for, okay, how are we going to try and fix this, because maybe we didn't make it out our 5 years. So those are all incredibly important considerations when making gifts. There's very limited exceptions when it comes to gifting where they will not affect long-term care assistance eligibility. There's tax implications to your decisions, and care being provided by a family member and compensated needs to have a contract, or else those are going to be considered gifts as well. So those are the three major points I wanted to bring up in this context. In addition, and this doesn't have to do with long-term care directly, but I'd throw that out there, that assuming gifts are going to be okay for the person's overall estate plan and not going to adversely affect their long-term care, usually if the person has IRA funds, those are the best funds to be providing to charities if you're charitably inclined. And the reason for that is you can send money right from your IRA during your lifetime. If you're over the age of required minimum distributions, you can send that money right to a charity and you're never taxed on those funds. So it's not that you're taking a tax deduction, you're never taxed on any of that pre-tax money to begin with. So traditional IRAs are a wonderful source to be able to do charitable distributions. So it's called a qualified charitable distribution. You'd contact your financial advisor directly. But again, keep in mind, that's not a safe haven for gifts that wouldn't count against you for long-term care eligibility. That's just a very tax efficient way to be making gifting. So the last thing I want to bring up in this is occasionally I have clients who they want to be able to continue making gifts for certain things. I just had a client, for instance, who it was a priority that upon graduation from college, they were gifting grandkids some money. And there was a large group of grandkids. And some of them were right around college age, but some of them were still in grade school. So for them to be able to continue to do that kind of gifting, because they wanted to send funds out to these people, if they just personally kept doing it, well, then that's going to be an issue because of the look back period, because the amount of money that they'd be gifting is going to exceed any of the relevant exemptions from these things being divestment. So the strategy that they chose to implement was that they were going to fund some money into an irrevocable trust, so that the trust itself, which they fund right now, so we get our clock started on our 5-year look back period, and that money is then outside of their estate, it's outside of our 5-year look back period, and that trust itself can then gift the money as each of the grandkids graduates college. So then it doesn't affect their eligibility, so that their 8-year-old grandchild, when they graduate college 15 years later, they're able to receive those funds, and it doesn't hurt the eligibility of the grandparent who maybe by that point is already in a nursing home. So there's different strategies that can be involved in this. There's no cookie cutter solutions for these types of things. It's very based on the objectives of the people and the situation and their financial situation as to what we might implement as the best solutions. But again, just be very cautious when it comes to gifts and know that there isn't a safe haven. I've used up most of our time in that explanation, but I would open it up to any kind of questions. Nicole, am I able to, I think I see some questions coming in. Am I able to?
Oh, those are not current questions, but if people do have any questions, there is a Q&A button at the bottom of their Zoom window. If you just go ahead, let's see here, we've got one. Does the gifting count for both as a couple? Case in point, I want to gift some money I inherited from my father. Would the 5-year look back count if it was my husband who needed the long-term care?
Ah, fantastic question. Yes, it's going to count for the couple. So the 15% of the gross income takes into account the couple, and then whoever needs the care, whichever one, doesn't matter who made the gifts, and who is going to require the care. The penalty would be assessed to the first person who is applying for the assistance in paying for care. Any other questions?
I am not seeing any additional questions.
All right.
So just a reminder that I would have for folks, if you do have more questions or you'd like one of the attorneys to take further look into your current planning or to look at your specific situation, we are sending out an evaluation right after this course ends, and there is an option to request a complimentary initial consultation right there on that survey. So that'll be in your inboxes momentarily.
All right. Well then, I appreciate everybody's time. I hope you found this valuable. It's you must have been very interested in this topic because it's beautiful out and you chose to spend a half hour in here with me. So I hope you found it worth your time. And as Nicole said, you know, us at Hooper Law Office, we're always here. You know, you can use us as a resource. We do complimentary consultations with families in order to look at their situation and be able to make recommendations on what's a good strategy and plan going forward. So I guess if there aren't other questions, thank you for your time. Again, I'm attorney Peter Harbach from Hooper Law Office, and everybody have a fantastic day.